Yes, sir. And good evening, Makhija sir, and all our participants. Welcome to all of you at today's roundtable discussion on proposed amendments in CIRP regulations and real estate related proposals. In the last discussion held on 16th November 2020, 16th November, IBBI's discussion paper dated IBBI's discussion paper of 1st November on proposed CIRP amendment was discussed. Your views and suggestions on the IBBI's proposal were collected, and ICSI-IP has duly submitted the same with IBBI. Now, in continuation of the said discussion, today we are conducting this roundtable discussion to deliberate on IBBI's another important discussion paper on real estate insolvency. To enlighten all of us with the proposed changes in real estate insolvency and their technicality, we have Ashish Makhija sir with us. Sir will also moderate this roundtable discussion to collect views from our participants. So now I am requesting Ashish Makhija sir to please share your thoughts and also kindly moderate the discussion.
Okay. Thank you, Peer, and welcome all my friends. A very good evening to all of you.
Sir, your voice is not audible.
It is audible.
It's audible.
It's audible.
Is it
I think
audible
it's
to audience?
audible.
Yes, it is audible.
It's audible.
Okay. So, friends, a very good evening to all of you. I think it's an important discussion
Good evening,
paper.
sir.
Yeah, good evening. Peer, can you just unshare this, whatever you are sharing on the screen? Can you just stop sharing it so that we can see each other, and then we'll share the discussion paper in a while. Okay, I think, yeah, this is better. Okay, so friends, a very good evening once again. I think it's important that in our discussion, because this is going to be interactive discussions, idea is not for me to speak. Idea is to collect views and thoughts of our friends, our IP fraternity, so that the final regulations which they come up, you see, changes in CIRP and liquidation, particularly in respect of real estate projects, now they should come in such form where they should withstand the legal perspective and also the views of the IP fraternity, because you guys are experienced. I mean, all of us are experienced in that. So first of all, friends, being interactive, may I request everyone to just please open videos, because I can see a lot of blank screens here. It is not that I want to speak to blank screens. So I will request, as I always do, so please open your videos so that I can see each one of you, and then we can interact, you see, in a better manner. Thank you. I think I'll request everyone to please do so. Okay, so friends, let's start with one of the important aspects, and which is sectoral wise amendments or sectoral regulations. Now, we have come to a stage where general prescription may not be rather found beneficial in respect of certain kind of sectors. And this is particularly true for real estate sector. Real estate sector is particularly very unique, where sentiments are attached, where emotions, you see, play a big role, because investors, the home buyers, have put in their life savings, and they are waiting for the flats to get it. Some are investors, I understand that, but majority of them are home buyers. In fact, I'm also stuck in one or two projects as a home buyer. So everyone is stuck somewhere or the other. So therefore, the major issue which comes up is, like, supposing I have not been able to file a claim, and I have paid, say, 50 lakhs or 1 crore to the builder. Now, what happens to my claim? Supposing I have not filed a claim, will it be written off? So the sentiments are little different in a real estate project than in case of any other operational and other creditors which are there. Anyhow, I'm not saying, I'm not commenting on any of these aspects, but there are 5 issues which have been identified by IBBI based on various committees, Amitabh Kant's committee, and then, of course, there was a colloquium on functioning and strengthening of IBC ecosystem. All these colloquiums and committees have given certain suggestions. So based on those suggestions, because it cannot be that only at one front the changes take place, it has to take place at a different front. Based on Amitabh Kant's committee, most of the state governments are also considering, particularly in UP, where a lot of projects are stuck. Now, the cabinet of UP is also meeting, most likely in December or in January, to consider all these relaxations and other things. So, at the end of the day, the issues have to be identified. And IBBI has identified 5 major issues. And they want that these changes to be take effect in respect of CIRP regulations as well as liquidation, because these projects can be anywhere. But typically, if these projects go into liquidation, it's a serious issue, because then home buyers they stand to lose in a big manner. And now the question which arises is that what needs to be done. So number one, friends, the first issue which is been taken up is mandatory registration and extension of projects under Real Estate Regulatory Authority, RERA. Now, we all know that in RERA, the projects of a particular size, typically all projects, because there are very smaller size projects, are not required to be registered with RERA. But there are many other, all big projects are required to be registered. So this is what you can see on your screen, the first item, registration. So they say registration of each project is mandatory. And 2, extension of projects under RERA. In fact, please just stay on the page number 1. We're not going to the first item. I'm just reading the first 5 points. So the first is this aspect. Can you just increase the size of this document? So one thing is very extremely important, friends, and that is that project, if it is to be registered, naturally IRP or RP or liquidator is not starting these projects. He gets these projects as a legacy of the stuck projects. So therefore, to my mind, extension of the projects is more relevant to seeking extension of projects from RERA is more important than mandatory registration, because registration in any case must have been done by the promoters. If they have not done it, of course, then it's a different issue altogether. But nobody can start a project. So anyhow, we will deal with that mandatory registration. Then second, which is a very important aspect, is that opening a separate bank account for each real estate project. Now, this is going to have a lot of consequences. Of course, as per RERA also, you have to open an account, but this is going to be a serious issue. So therefore, this is another aspect which needs to be discussed. The third point is the extension of registration or sublease deeds with the approval of the COC during CIRP. Now, if during CIRP, a possession has already been given prior to that, the coming into CIRP, or the project is complete. Now, whether the RP can go for registration or not of those projects, because there has been a doubt in the minds of many. In fact, I also gave an opinion way back in 2017 and 2018 that once all formalities are completed, CC and OC, completion certificate and occupancy certificate, is with the RP, then there is no encumbrance, there is no bar in handing over the project, the flats, and also for registration. So this has been done in a number of cases. We gave that legal opinion, and I'm glad that has now been, IBBI is also thinking on the same lines. But these are not with some fritters, so there are certain problems which are going to come. We'll discuss that. And then the point number D is COC to examine and invite separate plans for each project. This was also another difficulty which probably each one of us face, that the projects are located in different locations. Projects are at a different stage of construction. They are different in nature. Some are commercial, some are residential, some are a mixed land use kind of a thing. So those projects, and local builders or local developers are more interested in the local projects rather than all over India. So therefore, this was one of the other aspects, which is a good thing, I think, which we are getting now. And last is exclusion of the property in possession of the home buyers from the liquidation estate. Now, this is little serious, and I think we need to debate on this. So let's go to the first point. PD, can you just scroll to the page number 2, somewhere in the middle? Mandatory, where it starts with A, mandatory registration extension of projects under RERA. Now, the background of this is that Section 3 of the RERA requires that all projects need to be registered. We are aware of that. It's not something which is new. and the project must be, you see, more than 500 square meters, or the number of apartments are more than 8, then mandatory registration is required. So we always presume that as an RP, supposing I get this project, naturally I will presume that it is registered. If it is not registered, then it becomes the responsibility of the RP to get it registered. Now, what is the proposal? Can you just go a little above? The proposal is to expressly state that IRP, RP must comply with the provisions of RERA Act and regulations framed thereunder. It is proposed to mandate that RP or IRP to register all real estate projects under RERA, to extend the registration of the real estate projects under RERA wherein the registration is expired or about to expire. Now, friends, here there is a slight issue which is there. Number one, if a project, if you become an IRP or RP of a real estate company, and you find that the project has not been registered, so then you have to make all efforts to get it registered. Now, to write simply by saying that RP or IRP shall register all real estate projects under RERA, well, it's not that easy. For registration of RERA, you require a host of documents, which are very, very difficult for an RP or IRP to compile. I mean, it's very, very difficult. But in any case, assuming, I'm just assuming that in most of the cases, rather, I would say 95% of the cases, the registration would have been done, but it would have expired because the flats were not given. Obviously, that time period has expired. Now, the question is, whose responsibility is it to get that extension under RERA? Now, the IBBI wants to propose is that it should be IRP or RP. Again, number one, friends, let's consider this, and I will seek your comments on it in a little while. Number one, for extension of registration, there are charges which are required to be paid besides other documentation. Now, documentation is huge. Why there is a delay? You have to justify that. Number two, and of course, justification will be that the company came into CIRP and the promoters did not do that. That's a valid justification for all projects for RERA to extend. That's all right. But the point is, you have to collect, along with the application for extension, you have to file host of documents. What is the stage of completion, architect certificates, and many other certificates are required. Number two, then the question is of financial implication. The financial implication, my dear friends, you must be aware that in case of our RERA projects, for residential projects, 5 rupees per square meter is required to be paid if the project is less than 1,000 square meter. If the project is more than 1,000 square meter, which I presume will be in most of the cases, then it becomes 10 rupees per square meter. So now you can imagine that if it is, you see, a 36,000 square meter project, how much you are supposed to pay. That is only at the time of registration. And the maximum fees, of course, has been prescribed to be 5 lakh rupees. But in case of commercial, in case of, say, mixed use land, it is 10 rupees and 15 rupees, less than 1,000 square meter and more than 1,000 square meter. In case of commercial, it is 20 and 25. And at the time of extension, now that's very important, which people miss. You have to pay the fee double of what is the original fees. So it's a double of the fees. So it becomes 10 rupees and 20 rupees per square meter in case of only a residential project. Now the question is, how come the RP is going to find that money for registration, for extension of registration? So this is one of the things which I think need to be provided, because it's not simple registration or extension. Idea is how to find money, how to collect all the documents. So these are very, very extremely extreme things are there. Along with this, another proposal is, I'll just deal with the B part also, and then we will come, because IBBI is also proposing amendments, you see, in a continuous manner for first two items. Operating a separate bank account. Now they say that every project is registered separately. It is a given unique registration number. Filings are done project-wise. So therefore, the project-wise bank accounts are to be maintained. They say RPs, if you become an RP of a real estate project, there are 5 projects going on. RPs are not maintaining separate bank accounts for each project. Now, IBBI wants to say that, look, in case you become an RP, you see, it should be mandatory. It is proposed that IRP or RP should operate a separate bank account for each project undergoing CRP. Again, friends, it looks very simple on paper. But the fact of the matter is, there are common costs which are to be incurred, like a valuer is appointed for all the projects together. They are not appointed separately for each project. How will you distribute the cost to each project? And then will you be making to the valuer payment from 5 accounts, even assuming you are able to distribute the amount? So typically speaking, RP is more or less incurring expenditure which is of a general nature, general character for the company. Projects which are being undertaken actively, of course, there can be an project-wise account which can be there. And even in RERA, if we look at, even in RERA, now what is the requirement? The requirement is that an escrow account is required to be maintained. Money collected from each account has to be put in to that account, and 70% of that money must be used for that project. So even RERA also allows 30% use for the common projects or for other businesses of the company. I mean, the common expenses of the company. So here IBBI is strictly wanting the separate accounts to be maintained. Pete, can you just go to page number 9 now? So let's look at the, okay, you go to page number 3, sir. Let's just go to page number 3. Now, these are the 2 proposed amendments, friends, which are being wanted by this is the language. The IRP or RP, as the case may be, shall register real estate project of the CD under RERA if the project of the corporate debtor is not registered. And 2, if the registration has been done, the corporate debtor admitted under CIRP is about to expire or has expired, IRP or RP shall seek extension of such real estate project from the concerned authority. And 4E is also proposed to be inserted. The IRP or RP, as the case may be, shall operate a separate bank account for each real estate project. I think we have understood the problem. Now I will request my friends to just raise their hands, and one by one, I think we can invite them to give their comments. Yes, sir. If somebody has already given in chat box, we will consider that. But if you would like to unmute yourself and say something on these 2 items, proposed regulations 4D and 4E. Yes,
Sir,
I think
this is Kanti Ruski here.
sir, you have to open your video, because I think we would like to see your smiling face.
Okay.
That's better.
Is it enough smiling to make you happy?
No, it's not a question of making me happy. It's a question of that smiling face always makes things better. Yes.
Sir, so you are saying extension, which will like section 6 of the RERA.
Right.
And one thing is that you have raised is very well, that the money payable is very high, and how does that come? Secondly, the extensions usually come for 1 year and not for more than 1 year, which means it becomes a recurring expense till the time the CRP gets over. So that's something that I will, is that what they have in mind, that it is a recurring exercise and money is to be spent on something which is regulatory rather than on, the actual CIRP proceedings?
I think that's a very interesting point which you have raised. In fact, this is in one of our cases, the extensions are given by RERA only for 6 months, not even for 1 year.
So it becomes recurring, which is a
expense.
maximum period of 1 year under RERA, and they don't give it because for them it's an income for RERA authority. But for you as a RP, it becomes a recurring expense, and for COC. So just that's something that with my experience of RERA, I was thinking. And the second thing is that assuming the RERA does not give you extension, that is also a possibility, that is a discretion with them, then does it make the CIRP infructuous? Because what is the point of admission of a CIRP proceedings if the RP cannot proceed? So the 2 things can actually create more complications and make either exercise infructuous.
I think
the suggestion should be, giving the suggestion should be that once the CIRP is granted, then it should be deemed extension without any further act. And only an intimation to the RERA authority should be sufficing for extension till the time CRP is in existence.
And no extra payment.
No extra payment. Yes.
Okay.
That's what my suggestion is. But I leave it to you.
I think it's very wonderful of our friends to not only raise a problem but also give a suggestion. I think this is what is required. So thank you, Mr. Kanti Mohanji. See, the first point which he has raised is that it is not only one money, it can be recurring money which we have to find because these are recurring extensions. So how to find money, I think that's a major problem. Number two, if the extension is not given as our registration not given, then what will happen? That means the project cannot continue because as per the law, then you cannot go ahead with this. So what happens to that? So his suggestion is that there can be that once the company comes into CIRP, let it be a deemed extension. Let it not be burdensome for the CD at this stage and as well as for the RP, because then it is going to create problems. Collecting documents is a big problem. So thank you, Kanti Mohanji. And I think now we can hear Mr. Matthew Tharakan. Yes, sir. Go ahead.
Yes, sir. I just support Kanti Mohan and want to say further in the sense that, as he said, by virtue of the real estate project hitting CIRP means that it has become a bad asset. Okay, it has hit the society. So therefore, it should be deemed without any kind of procedure or anything like that. A built-in provision has to be in the IB, in the regulations, that it is deemed as extension. And if RERA authority is particular about the fees, then of course it can be made as a due in the event of, as an unsecured creditor, in the event they can also have a claim on it.
Or rather more than that, I would suggest, because it is related to an ongoing project, it should be made as a part of the CIRP cost, isn't it?
Exactly.
Yeah.
Exactly.
So then they are sure of that whatever plan comes, the person, the RA is going to pay the fees first, whatever extensions were required at that stage. I think that's a good suggestion.
Yes,
so finding money is taken care of in this manner, that it is treated as a part of the CIRP cost, which is to be paid if the plan is approved. And then naturally RERA will get their money first also in that case, because any builder who is going to come, RA is going to come, he is going to pay for that. I think these two are good suggestions. Anyone who wants to contribute on 4D, then we'll go to 4. Yeah.
Sir, my suggestion is that it's a humongous task to get the registration, new registration, or to get the registration renewed, in which case it has been lapsed. So there should be a direction like that administration should help the RP to get the registration renewed or get that registration renewed or get a new registration. Another thing, that the registration amount can be paid on due basis. Whenever any allotee would be handed over, you would have to pay the registration amount. That can be done.
No, see, there are two things. As far as registration of the individual home is concerned, naturally, that is to be paid by that buyer only. Here we are talking about the RERA registration of the project. Now, it is very difficult to divide on the basis of, because there are certain common areas are also there. So how much common area for which he is going to pay, and then at the time of registration, I think the suggestion which has come is that, look, it should be treated as a CIRP cost or a liquidation cost. I think that's a better suggestion. Now, the only point which you have raised is that, look, collecting of documents is also huge. Now, if the registration is already there, then naturally you may have some kind of documents available. And if the promoters are supporting, if the promoters are not supporting, then it is going to become a huge task. I definitely agree. But taking help of administration, I don't know how far that is successful, but we make note of that. Okay. Yes, I think we go on.
Another thing, sir, which it is also a huge task.
But if you have to add on, Mr. Rajan, if you have to add on to that, then you have to open your videos. Without video.
Yes, sir. Sure. Sorry.
Yeah,
yes,
I think this is better. Yes.
Yes.
Okay.
Actually, it will be a huge task for the RP to get the fund, and to in that case, the fund can be paid on due basis. Whenever the common areas would also have to be allotted, the cost of the common area would also have to be allotted accordingly, like this. And whenever any amount would be any unit would be handed over to the person, to the allotee, he would have to pay that amount.
So you are suggesting that a proportionate cost can be allocated to each
Yes,
home
sir.
buyer.
Yes,
And
sir.
then- Okay, okay. I think your point is taken, sir. Okay, we'll
Yes, sir.
definitely include that in
Thank you,
suggestion.
sir. Thank
Yes, I think Mr. Sharma is also there. Yes, Mr. Sharma. One by one, we'll go. Then Mr. Gautam Bhattacharya, then Bhuvaneshwari.
Sir, it will be very difficult to convince the regulator that this amendment should not be carried out. And if you go with the background which came 4 or 5 months ago, that the call is that real estate bankruptcy should be handled by RERA and not by the IBC, which is not going to be very easy. My suggestion is that we request the regulator that let RERA give a very simplified form for a fresh registration or for extension. Let the form be very simplified and let RP fill a simplified form, and the cost, if he is not able to deposit, let it be treated as a CIRP cost, because generally RP does not get his fee, other people don't get their fee. Let him give an undertaking that this is included in CIRP cost and come along with resolution.
Okay, I think your suggestions are good, Sharmaji. The only thing is, nobody is against this, proposed amendment. Nobody is saying that we should not bring it. We are trying to discuss a way that it should be brought in a manner which is more practical. That's what the idea is. I think your suggestions are well taken. Yes, Mr. Gautam Bhattacharya. Go ahead, sir.
Good evening, sir.
Good evening. Good evening.
What happens if already prior to the triggering of CIRP, if the RERA has already transferred the project to Association of Allottees, RW has been made, project has been completed, possession given, but simultaneously one of the projects went under IBC, and the RP included all the projects under the CIRP, and they have asked RERA to stop any further activity. So once the project is already handed over to the Association of Allottees, will this registration be required for them?
Okay, I think, sir, we are again mixing the two things, because here they are talking about registration of the project. So, see, the point is, if the project has been handed over, possession has already been given, then the question of the RERA does not come, because once you have handed over, then RERA is not applicable for that project. Then everything is complete under the law. I'm believing that. Now, insofar as bringing all projects under CIRP, not in one, that is why there is another suggestion that project-wise CIRP should also be given. So I think that will take care of it. We were going to discuss that also. Your point is well taken, sir. I think
Thank
that's
you.
which you have raised. Yes, Bhuvaneshwari ma'am.
Yeah,
Good
good
evening.
evening, sir.
Yeah.
Here, my view is that if the RP is going to continue the construction or start the construction, then RERA registration may be required. However, if the project is abandoned 5 years or 10 years back, and during CIRP, our job is to find a resolution applicant. The resolution applicant is going to decide the drawing, how many flats are to be constructed, what is the area to be constructed, and all that. When that is the case, on what basis we can go ahead with registration under RERA? In fact, I have my own cases where there's 100%, there's a half constructed project, 100% deviation is there. Now, even if the resolution applicant comes, he has to demolish the whole thing and then restart the thing. So what is going to be the area to be constructed? What is going to be the plan? Accordingly, the RERA registration is to be done. It's not that just like that, go and register RERA under the project name. With a lot of information to be provided. So that is, so it can happen only when the resolution applicant comes and when he starts the construction. That's why even for him, 1 year time is given to get the government approvals and all that. So at this stage, if I am going to do some registration for name's sake, just because IBBI says I will do one hodgepodge registration, which will create more problems for the resolution applicants.
Okay, so your view is, if I take your view, that's a valid point which you have raised, which means that this particular provision should not be there, that RERA registration by RP should not be done. That's what you're trying to say?
Exactly.
Okay.
Unless otherwise, COC says you have to start the construction and I am going to start or continue the construction. Then if RERA restriction is not there, then it is possible.
But IBBI is presuming on an ideal state that for every project, it has to be a going concern. So therefore, it has to be made as a going concern by the RP. So construction has to be started in all cases. That's what they presume. That's what I'm
It's
saying.
not possible, sir. It's not possible because of our practical experience.
Yeah, you are absolutely right. In fact, in many projects, there are deviations, which you have mentioned. Now, if the deviation is there, their plans are not going to be approved. And if their plans are not going to be approved, naturally, RERA will also not register it.
Yes,
So because
and
of
if I do
deviations.
the registration, it is going to be the counterproductive. That is my opinion. In
So
addition
your
to time and
so,
cost.
so what is your comment on, like, people are saying that let it be a deemed registration for the period. Whatever original registration was given, let it be continued as an extension. So then there is not going to cause any problem. So
That
whatever
is, if it's a single letter to the RERA department to continue the registration as such, that's fine. But most of the projects what we are handling, it's the pre-RERA period.
Okay. So
There
therefore,
we have to-
so what we are saying is that, look, insofar as the RERA period constructions projects are concerned,
yes.
there should be a moratorium as far as the extension is concerned. They should not withdraw that registration. So moratorium in the sense means extension will be there. But for pre-RERA projects which were started earlier, yes, your points are valid. I think they must be taken into consideration, because original registration is very difficult to obtain, because you have to submit host of documents, including the plans and whatnot, even the sewer, water, sewer, architectural drawings, and many other things. And again, it involves a huge expenditure, because it involves a lot of professionals to be taken.
So
I think
we are not talking about only the expenditure. We are talking about the legality of the plan and the data information, what is going to be registered. That itself is a question. That's my opinion, sir.
Yeah. So half-baked registration will do more harm to the project. That's what you're trying to say. Okay, I think that's a good point. Yes, I think, friends, if there are no more comments, we would like to move on the project-wise accounts. If very quickly anyone wants to make a comment on. Yes, Mr. Budesh.
One question, that post-registration, there are compliances also. The moment you get registered, there are monthly, quarterly compliances to RERA, which RP does not do right now. We only intimate to RERA.
I think that's a valid point. That's a valid point. Okay. Yes. So, I mean, can you just
very quickly?
Yeah.
So mainly on the registration part. So if we can add, because see, with these changes, we are getting into too much into the commercial aspects of a project, and that always varies project to project. So let the involvement and the owners also to be there on the COC, because that's where the basis the actual progress on the project or the real situation. Let there be a joint decision, and basis that if the situation is warranted, let them take a call. Otherwise, what happens is basically practically, as mentioned by Bhuvneshwari ma'am and others, every project is unique, and that's where the resolution is getting difficult also in real estate. But let there be involvement of a stakeholder, and commercially let them decide, so that the cost related aspects, compliances are also being taken care of by the ultimate beneficiary of this process. So that's my limited point, because otherwise owners on RP will basically, that is there. Once you change the law, RP will try, but issue is that how you convince the non-compliance will still remain on the RP part rather than basically COC or the other stakeholder.
Okay, see, there are two things which are coming from what you are saying is, but let us understand one of the important aspects. The regulations even today say that RP has to comply with all provisions of law, all laws, right? Isn't it? It is already there in the law itself. The question what the IBBI is saying is that, look, these projects are important to be registered, and therefore that compliance must be made. So supposing you take it to the COC and COC says don't register. Now, that's not a good idea. So going back to COC, seeking their permission for registration or non-registration is not a good thing. The only thing is you have to find out a way that, look, this is a law. We need to register, find out the money. You contribute money, I will go for extension of the registration. So here the solution people are suggesting is there be a deemed registration or extension during the period of CIRP, just like in the case of moratorium. And as far as the money is concerned, which is payable to RERA for registration or extension at any stage, then it can be treated as a CRP cost to be paid by the RA, or it can be paid as per the plan. So this is what people have suggested. Yes, there are difficulties, as you mentioned, the document collection, the filing of those documents, then the plan should be correct. Those issues are there. I think we have already collected those views. Thank you, sir. Now let's go to the second point, which is opening project-wise account. I think I've already mentioned that as per RERA, you have to maintain an escrow account, and only 70% of the money is mandatorily to be used for that project. So 30% can be used for other purposes like general purposes. Now here there is a problem that, look, if there are 5 projects and I open 5 accounts, then how will I maintain? Because most of the time, whenever the RP is appointed, the projects are abandoned, kind of thing. That nothing is going on for last 2 years, 3 years, or 5 years. So what is the point of opening 5 bank accounts and then dividing all the costs into 5 accounts? I think I'm not really able to understand. I think this should be made. Some changes are required in this. I think I would like to have views of our fraternity now. Yes, anyone who has got a view on this? Yes, ma'am. Yes, Bhuvneshwari ma'am, go ahead.
Yeah. Sir, if the CIRP is going to be project-wise, naturally we will open a project-wise bank account. However, if the CIRP is on the CD, and as you rightly pointed out, there are several assets, but there is no inflow of the money, and the CIRP is on the whole. Maybe we will come out with a project-wise resolution. That's a separate issue. But if the CIRP is on the whole CD and the inflow of money is except the CIRP cost, nothing else is, no other money is coming in, I don't see a reason for opening a bank account for each project and keeping it empty.
And then
we have to pay minimum balance to each account.
Yeah, and supposing you have to pay money to a lawyer. Now that's a CIRP cost. Now will you take money from 5 accounts to pay him? That is another thing which needs to be considered by IBBI. I think this is one of the greatest problem which should be there, which will be there in any case. But ma'am, one more thing. Assuming you said project wise, you see CIRP. Assuming you become, you see, there are 4 projects and 4 projects are differently taken and you become the RP of all the 4. Now you are, see, naturally the CIRP is related to the CD. It may be for a single project that is going to create a problem, but at the end of the day, in fact, I just read one of the judgments, which is very interesting judgment of NCLAT. It has come very recently. It says if you are conducting CIRP project-wise, moratorium applies only to that project and not to the CD as a whole. Now, this is interesting. That means bankers can go ahead. I mean, how will you identify? Because you see the assets have been charged of the other project and not of this project. Then what happens? I think we are getting strange judgments also. I don't know how far that is valid, but anyhow, yes.
Sir, right now I am holding 2 project-wise CIRP of the same CD, and I am the IRP and RP for both the projects. I have opened 2 separate bank accounts. Even then with the bank, when I opened an account, when I opened first account, they gave me a bank account, user ID, password and all that. When I opened the same account for the other project, they said it is opened. It is not there. I could not make out. So I asked them, no, you go to the same user ID and log in. So login and password, when I did, inside it says 2 different projects, 2 different things. So within the same login ID and password, I have got 2 windows.
No, but how do you bifurcate, like common costs, like lawyer cost or say valuer cost or many other costs of CD, the CIRP cost? How do you bifurcate between 2 accounts?
Sorry, when it is a project wise, I am not bothered about the CD at all. Only the project matters to me. If there's an avoidance transaction on the project, I go and file an avoidance transaction application. All the costs are separate for each project because each project is an individual CIRP for me.
No, that is easier said than done. Supposing there is an arbitration which is going on, it is not for a single project. It may be for the entire company as a whole. So then how will you deal with the arbitration? Supposing you have to hire lawyers for that arbitration matter, how will you distribute between 2 projects?
But unless my project is affected, I am not going to bother about the arbitration.
No. Okay. I think that is another issue because you see, at the end of the day, then do you think that the promoters who are already in charge, they should take care of those arbitrations then?
Maybe that is how it is. Law is not clear right now. It is project-wise CIRP is admitted, so I am concerned only with the project. If I trespass, then somebody else is going to put an application on me. But for me, it is very clear. It is this project, the CIRP is.
Okay, understood. Okay, I think let's go to Mr. Suresh Agarwal.
If your project is a subject matter of arbitration,
Sorry.
Yeah, in that case, I will proceed. I will do whatever is required as per law with respect to arbitration.
so,
If my
what
project
Mr.
is part of
Makhija
it.
is saying that assume that both your projects are somehow a subject matter of arbitration, then will you appoint two separate lawyers or one lawyer for both taking care of each of your projects? And how will you allocate costs?
I may appoint one lawyer, but that lawyer will represent both the projects independently. And for each
Mr.
project,
Makhija's
there will be a
question was,
fee.
how will you allocate the cost between the two projects?
No, the cost will be, the fees will be separately paid for each project, and accordingly it will be done. It will be
I think let's not go into the finer points, because we have to discuss. Of course, we are discussing the issues also. Yes, I think Mr. Suresh Agarwal is waiting patiently. Let us give him a chance now. Yes, sir.
Yeah, sir, we are handling a case where already there are many projects of the CD. But the CIRP is only on the one project. So, you are talking about the common expenses. For that, we have done is we have opened a head office account. So, whatever are the common expenses type expenses, they are debited to that account, and whatever is directly attributable to a particular project, that is put into that project-wise account. So
I think
that's how we handle it.
Yeah, I think this is a wonderful thing. In fact, one common account should be there for the corporate debtor and then a project wise. So if any construction related expense or say specific related to that project, that will be taken out from that particular bank account. Otherwise, it's a common cost which can be taken out from the common account. I think that's a good suggestion, sir. Okay. So I think instead of saying only this, it should also include that for common expenses, the bank accounts can be operated by the IRP/RP. So this change is relevant, right? Yes, Mr. You want to say something more?
So this will also help in getting project-wise finance. So if the common cost would be allocated according to a basis which would be logical, then also it would be beneficial to get the project-wise finance, interim finance.
And tell me, sir, on what basis you will allocate? Now, there are two bases in which we also did, because the first case, you see, in India, we came out with a project-wise CIRP, which was not there in any of the project and any of the law, but we came out with those. And the basis of division, I must tell you, one, we considered on the basis of the claims received. So claims received is a better area, because that is what it is there. And then the cost already incurred. So therefore, the cost already incurred. Supposing on one project, I've already incurred 70 crore. On another project, it is 20 crores. So, the area, the square meter can also be one of the criteria for distributing it. Anyway, that is, of course, how the distribution will take place. It can be on the basis of the claims, or it can be on the basis of this, square meters, whatever the area of the projects are. Okay, I think these are good suggestions. So let's move on to the next one. The third one is execution of registration or sub-lease deeds with the approval of the CIRP during the CIRP. Now, naturally, the opening sentence also says for a business under CIRP, IRP/RP needs to ensure continuity, which may involve the acquisition and sale of inventory. However, the real estate sector presents a unique challenge. In some cases, creditors have fulfilled their part of obligation in the contract and the CD has also constructed, but the formal handover is pending. Now look at this. Flats are complete, but handing over, that means possession has not been given. So now the courts have also given various judgments. So I think we can skip these. Pete, you can just, can you go to the next page now? Now there is point number 6. And in fact, point number 5 also let us read, because I think the proposed amendments are going to come from that. It has been observed that in few cases, the allottees are interested in taking possession of the units on as is where is basis. That means supposing internal flooring is not done, by the builder. They say, give it to us, we will complete it. So this is the way as is where is basis, and would get the remaining development interiors of their home finished from balance funds which have not been paid by them. The objective in the resolution of the real estate is a smooth handover of the units to the rightful home buyers. Thus, to expedite the resolution process and avoid delays due to unnecessary holdups, the allottees can be given option to take possession of the units on as is where is basis or on payment of the balance amount, if any, after taking it into account the funds due and so and so. Now, and then they say your registration can also be done. Well, friends, it looks very simple on paper. Let's look at the proposal first. To facilitate the smooth handover of the units or where possession has been transferred, it is proposed to allow RP to hand over of a ownership of a plot, apartment, or building through transfer during the resolution process with the approval of the COC. Further, to avoid delays and unnecessary holders, it is also proposed that with the approval of COC, RP may be permitted to hand over possession on as is where is basis or on payment of the balance amount after taking into account the funds due and funds required for completing the unit. So this is 4F. Can you just scroll up a little bit to 4F? Yeah. So this is the same thing, and now this is the language of the proposed regulation. Friends, I have few comments to make before I take your views. Number one, handing over possession. Whenever we talk about possession, my dear friends, we should always mean it as a legal possession. It can't be something outside the law. A legal possession under RERA can be handed over only after obtaining the CC and the OC, which is a completion certificate and occupancy certificate. So here we are promoting on as is where is basis means the project is not complete. There is no CC, there is no OC. Maybe the firework is also, formalities are also not completed. Water, sewerage may not be completed. In such a situation, if the COC says tomorrow, and naturally COC will always say, give us the possession. I'm telling you, in 99% of the cases, COCs consist of home buyer. They'll say, okay, give us possession, we will complete it. But what happens to the common facilities? What happens to the other areas? I think to say this, that on a as is where is basis, by approval of 66% of the COC members, it should be given. I think it is very far-fetched. It is going to create a lot of problems. And then I think I would like to have comments from our friends. Yes, I think Mr. Pavan Kumar. Yes. Can you share your view, sir?
So I echo your views that handing over a incomplete house or accommodation is too risky a proposition from different angles. What
Right.
will happen if there are serious accident and there's a loss of lives? Who would be responsible at that stage? Because ultimately RP is the person who is responsible for a company under CIRP. So
And I think
this would
your
have
point,
a
yeah.
far-fetched thing.
Yeah, your point is very valid, because you see, two buildings may be very close to each other. One building might be 90% complete. The other building is under construction, which is 40% complete. And the construction activity going on, something happens to the residents there. I think this is going to be a serious issue. I think very valid point raised by our friend, that it is a risky proposition also. The safety is also required to be seen in such cases. Yes, yes, Bhuvneshwari ma'am, and then Mr. Ravindra Belur. One by one. Yeah.
In my view, this is going to create a total mess. Because in some cases, only the foundation is done. There is no flat at all. It's only space. And the buyer has paid 100% of the money. Will you allow will you hand over the space to him? Secondly,
well, I think
yeah.
I think if you ask me in a lighter vein, I am also stuck in a project where I have booked a plot, not a flat. It was a plot.
Yeah.
Now all our home buyers association is saying कि plot में क्या करना है, अब हमें plot handover कर दो demarc करके. But the point is, there is a sewerage, there is a water, there is electricity connection, which those have to be laid out. It's not that simple. You have to hand over a plot. So as a home buyer, I may want it, but at the end of the day, this is going to be a complete mess, as you mentioned. Yes.
Second thing, even if in many cases, in some cases, civil structure is there, nothing is done. In fact, the cost of completion, the finishing work cost is more than the cost of the civil work.
True. I agree.
Even if you try to complete your flat after taking possession, what will you do with the neighbor? You have to walk on rubbles on day-to-day basis.
Absolutely. And supposing the staircases are not done, the lift is
Yes.
not complete. So how will you do that? How will you walk up?
And you are on the 20th floor. How will
Yes.
you go to 20th floor
Right,
daily
right.
and come back?
No, I
And
think
how about the OC, getting the common amenities? Nothing is going. I think it will be only on paper in that case. Once you hand it over, it's going to, I don't know what relief we are giving to the home buyers.
And another thing is they are saying that look, on as is where is basis for non-payment of the balance payment, because from that balance payment they say we will construct internally. Now, how will you identify that what is the stage of construction? So supposing the flooring is not there, how much you will deduct? So
Yes.
therefore, I think it's rather than making it easier for RP, we're making his life difficult, his or her life difficult. I think this is not a good thing to hand over as it is. So are we saying that it should go away together? I mean, that's what we are wanting to do. Okay. Yes, Mr. Ravindra Bulur, and then Mr. Kanti Mohan can, I think, share their views.
I have a very basic question. I think you only can answer.
Yes.
First of all, is it legal for IBBI to come out with a proposal like this, which is violation of many acts, including the safety, occupancy, and all that? I mean, that is my very basic concern. Forget about everything else. Is it legal? Is this proposed amendment? Is it legal?
On the one hand, you have raised a very interesting point. In fact, I wanted to mention that. On the one hand, we are saying RP should comply with the provisions of RERA for registration because law is to be complied. On the other hand, we are asking RP not to comply and hand over the possession because in RERA, it is mandatory that unless and until you have CCOC, nothing can be done, no possession can be given. So therefore, you are actually doing something which is not legal. If you want to have my opinion, it is completely outside the provisions of RERA. As is where is not mentioned anywhere. So I think that's a good point which you have raised. Yes, Mr. Kantimohan.
So I was just endorsing what you are saying, sir. It is violation of section 19.3 and subsection 3 and 19.5.
I agree, sir.
Under section 19, subsection 3 of RERA, he is entitled to common areas and get all the documents, the allotee. So if you are not doing it, you are actually violating RERA, and then as an RP, you will be answerable to the RERA authority as well as consumer protection laws. So
absolutely,
this insertion as such is in violation of RERA. That's
and,
what
and then and then RERA is not required. Then see the point at the end of the day. On one hand, we are saying registration is mandatory, but then you are wanting to hand over flats which are incomplete. So then the RERA is not coming into picture now. So what is the point? I think this 4F is a serious one, and I think all of us are agreeing that
to our mind is ultra virus, sir.
Okay. I think we'll note it down. Yes, Sharma ji, very quick, sir.
RERA registration point came only when the RP thought that RP can get money for unsold inventory. It is only at that stage it is required, and I think we should only in the point 4F you should say that he can allot the finished and legally completed apartment areas, which are legally COC.
Sir, where is the confusion? See, the point is not that. Let's look at the preamble, which I just read. They say, as is, where is. If it is finished, it has to be handed over. There is no question. Then we don't require a law for that. Then we don't require a specific provision. But if you go by...
preamble says this only, that where the builder had completed it, all things were... Preamble should restrict to that only. You should not talk of anything else.
So how...
completed units.
No, sir. Completed and completely finished are two different. So let's look at this. The building is complete. Finishing is pending, as Bhuvaneshwari ma'am also said. Now, can you hand over? Because here they are saying, because if it is complete in all respect, even the finishing is also done, then there is no problem in handing over. Then you don't require a law for that. Here there is a specific provision they are going to insert on as is, where is. Let's focus only on as is, where is. Whether it is 50% complete, as is, where is can be 50% also. As is, where is can be, वो चार दीवारी खड़ी है and the home buyer says, मुझे दे दो मैं अंदर कमरे अपने आप बना लूंगा. Is that possible? That is not. I think the stage is also very important and it is against the law. That is what we are discussing. Okay. I think let's move forward. I think we have debated on this. Let's go to the next point now. And the next point is COC to examine and invite
What
separate.
is your conclusion on this? That we
So my
should be the
conclusion is,
modification?
so my conclusion is that this modification is against the law, as one of our friends, Mr. Kanti Mohan, also said, because without CC, without OC, it cannot be there. And if you already have CCOC, then you don't require a law specific provision, which has been done in many cases earlier also. Yes, if there is a dispute or a doubt that whether RP can hand over, because some RPs were of the opinion that it violates moratorium. I cannot hand over plots or flats to the home buyers. Well, in that case, maybe a small clarification can be added, saying that, look, that is possible. And if everything is complete, CCOC is there, then possession can be handed over by RP. It is not a violation of moratorium. In fact, there are a number of judgments now on that. Okay.
Sir,
Now,
sir, but initially you said that when you say handover, it is a legal handover. There will be a legal document by which his possession and ownership is transferred. Then why we call it as it is not legal or it is against the law?
And number two, sir, another important point. Supposing I hand over the possession, or supposing some illegal possession was given by the builder itself. Now what is the next stage? Registration. Now, can the registering authorities, will the sub-registrar register it without CCOC? The answer is a big no. Whether the company is under CIRP or not. And if the registrars are going to permit for the companies under CIRP, then others will go to the court and they say, why only these projects? Why not all projects? So therefore, I think the legality has to be tested. And according to us, according to me also, and to many other people, this is not a legal possession. So I think this will create more problems than.
Sir, I want to explain one more situation what I am facing.
Yes, ma'am.
When the foundation or small amount of the civil work is done, some of the home buyers, with collusion with maybe they were very good with the promoters, they got their flats registered. Flats which is not existing got registered.
Yeah.
Now we found that the building is 100% deviation, and the resolution applicant, the option for the resolution applicant is to demolish and reconstruct.
Correct.
Now what happens to those already registered flats?
And supposing you are an RP and the COC says register, you take money, naturally you'll have to take money, the balance money and the registration money, and you register, then the FIRs will be filed against the RPs.
Exactly.
On a 100% deviation project, you have registered the flats. So I think
already wondering what happens to those registered flats if the building is demolished. Where is the flat? Except the uninhabited area share.
So let's see, Bhuvneshwari ma'am, what is the final outcome of this regulation? If assuming it comes in the same shape, then I think we'll have to find out a way what precautions or the safety net is to be taken by the RPs. We'll discuss it later once these proposals are already there. Okay, so let's go to the D point, COC to examine and invite separate plans for each project. Now it says CD is associated with the real estate as multiple projects. So like supposing CD has come into this thing. It is not for a simple one real estate project coming into CIRP, supposing the entire CD comes in. Now, the question which arises is, should the RP invite project-wise plans? The answer is yes, it should be done. And it was the need of the hour. The law was not clear. We have done in few cases. But now, what is the proposal? Let's look at it. In view of the foregoing discussion that each project needs different treatment in terms of resolution, IBBI recognizes that. It is proposed to clarify that COC on examination may direct the RP to invite separate plan for each project. It would also encourage an association of allottees of a real estate project to bring their own resolution plan and resolve issues in a specific project. So they are just proposing to add only a clarification. And the clarification is RP on the proposal and approval of the committee may invite a separate resolution plan for each real estate project or group of the projects of the corporate. So any comments on this particular aspect? Any comments? Yes, ma'am. Go ahead.
Can we talk?
Yeah, please go ahead.
Okay. Sir, if project-wise, if the CIRP is on the CD and if the RP is allowed to asked to do a project-wise resolution, in my opinion, maybe the common COC may not be the right thing. Maybe we should have a project-wise COC or a sub-COC, something like that. Anyway, they can change the resolution, regulation and bring anything. So project-wise subcommittee or a sub-COC, so that each subcommittee approves for their project. Otherwise, if the COC mainly consists of one project, and for all other projects resolution are happening, that COC is going to oppose everything, or they may not be in favor of it. So I feel the concerned COC will take a decision with respect to that project. So
Okay.
COC may not be the right idea if you are going for a project-wise resolution, sir.
So project-wise moratorium has already come in by way of an unclaimed judgment. So now you are trying to bring in project-wise COC also, which is not a bad idea, because I think I support to larger extent, because in one of our cases, same we called for project-wise plans and the project-wise plans came. Now it was put to a common COC. Now for that project, the percentage of voting was only 20%. Now they could not approve it or reject it. But supposing they want to reject it, but other 80% approves it, then they are in trouble. So I think that's a good idea, that there should be a mechanism to find out a way that COC which consists, but only point is, what will happen to the common operational creditors? Will they be part of every COC then? Because they are not project related. Some creditors may not be project related. They may be common creditors, like bankers who have given loans for the entire CD, not as a project-wise this thing. Will they be a part of each COC then? So I think those questions are to be determined, but this is a good thing. I think we will definitely put it in our suggestions. Yes, Mr. Amin, go ahead, sir.
Yeah, so I second view. So I second views by Bhuneshwari ma'am, and I think this is the solution to the earlier, amendment. Because see, if the Association of Home Buyer wants to do that, rather than RP being involved in this, it is better that let them propose by way of a resolution plan and get this thing resolved. So that's a better way of resolving, rather than put onus on RP in the process of getting these things resolved. That's my limit.
No, that's all right. See, I'll tell you what happened in one of our cases. We called for the entire resolution plan for the entire CD. No plan came. Then we thought out a way that we brought out Form G, where we said if somebody wants to come in for the entire company, let him bring the plan. Otherwise, these are the project-wise plans can also be brought in. And fortunately for the RP, the project-wise plans did come and they were actually approved by the adjudicating authority. So naturally, it was done with the approval of the COC. RP cannot do it on his own because it becomes a difficult issue. Again, tomorrow he can be the scapegoat for that. Okay. Yes, let's go to Mr. Gautam Bhattacharya and then Mr. Sharma. Yes, sir. Very quickly. Mr. Bhattacharya, you'll have to unmute yourself. Okay, I think he's not unmuted. Maybe, yeah. No, okay, you were unmuted, sir.
Makhija ji, meanwhile, I'll take it up, because you see, this accepted as it is, because in normal resolutions, where in one of the companies we had a steel unit, automobile unit, and other units, so we called for a unit-wise plan. Whether one unit get a bid or doesn't get a bid, the resolution did not stop. I don't think there is anything wrong with this amendment or any clarification required. What is the problem with this modification in the...
But the point what we are discussing today is, like you also mentioned that there were two projects like steel project and other project you called for it. Now, they were not real estate projects. They were different projects. So are you suggesting that it should be done for every company, that for separate projects, separate resolution plans can come? Or we are only talking about real estate?
Sir, wherever there is a situation, RP can say you can bid for the organization as a whole.
Well, then
unit-wise.
Well, then it can't be for real estate project or group of projects of the corporate debtor. Anyhow, I think that is a separate debate, but we are only concentrating right now on real estate. So that will be there. Yes, Mr. Bhattacharya, I think you are unmuted.
I just wanted to know if this regulation goes through, that it will be project-wise resolution rather than the corporate debtor as a whole. Will it be prospective or retrospective? Because in some cases, they have already clubbed all the projects. So if this regulation goes through, will the existing cases also...
I think that's a legal thing, but at the end of the day, whenever a clarification is inserted, let me say from a legal standpoint, whenever a clarification, it is typically presumed to be from a retrospective effect, because clarification is only clarificatory amendment, and clarificatory amendments can be retrospective also, like in the case of section 238A, when it was inserted where the limitation is applicable. So the Supreme Court said it is a clarificatory amendment, they can have a retrospective effect. So that, of course, we will examine that later on, whether it is applicable for the future projects or the past project. That's a separate issue, but it's a good question. I think you have raised a good point. We will definitely bring it to the notice that IBBI can also clarify that this is retrospective or prospective, from which date it should be applicable. If they clarify,
Thank you.
Yes, good point.
Thank you so much. Thank you so much. Thank you so much.
Okay, so now let's go to the last point, which is there. Exclusion.
Sir, what is your suggestion on this?
Sir, my suggestion is that a project-wise resolution is welcome. There is no doubt about it. It should have been done much earlier. It is being done today. I think we should not. But as our members also mentioned, there need to be little safeguards on this, because you see, for a project which is only say 80 home buyers, for a second project, supposing assuming there are 1,000 home buyers. Now 1,000 home buyers can bulldoze 80 buyers. So this is where Bhuvneshwari ma'am has come, that project-wise COC, I think that requires some thinking on it. Not today, maybe in future. That suggestion we can give. Okay. Okay, let's go to the last one. Exclusion of property. Hari Prasad, can I request you? Yeah, thank you. Exclusion of property in possession of home buyers from the liquidation estate. Now, this is a serious proposal, friends. Let's try to understand. This is very, very important. Now, they say that home buyers are financial creditors. We all know now, because of insertion of explanation to section 5(8)(f), which was there. They say in para 2 that there is some confusion in the market as to whether the properties where the allottees have taken possession, but registration with an authority of transfer is pending, are to be included in liquidation estate or not. So then they have quoted certain jurisprudence where the different jurisprudence have been there, whether they should be included or whether they should not be included. So let's look at the proposal straight away. Please go to page 7. Point number para 4. We'll read that para straight away. We're not going through the jurisprudence. I think most of us are aware. Section 36 of the code defines liquidation estate, which states that for the purposes of liquidation, the liquidator shall form an estate of the assets, which will be called liquidation estate. Clause 4 of 36 of the code states a list of assets which shall not be included in the liquidation estate and shall not be used for recovery in liquidation. 36(4)(e) also gives power to the board IBBI to specify any other assets which shall not form part. So now they are using their powers under 36(4)(e), and now they are trying to bring regulation 46A. Let's read that 46A. Can you just scroll it a little bit? For the purposes of section 36(4)(e), wherever an allottee as defined under clause D of section 2 of RERA is in possession of the unit, it shall not form part of the liquidation estate of the corporator. Friends, what is the idea? The idea is they say, look, if a person has been granted possession, should that asset be again included in the liquidation estate? Because if it is included in the liquidation estate, who has got a right to sell? The liquidator. But some family is already staying there, or somebody has the possession there. So will you first of all depossess them, because you have to evict them only to sell it, or you have to sell it as is where is basis. So the question is this, number one. Number two, but here, friends, two things I think the distinction must be made, as we made in the earlier clause. Possession, is it legal or illegal possession? If CCOC has been obtained, possession given, naturally it will not form part of liquidity. There is no qualification required. But if you have been given possession without any CCOC, now here the IBBI says, please do not include in the this thing, and because it is already in possession of that person. I don't know how far this is legal. Let's have the views of the participants here, and then we will try to form the conclusion. Yes, I think Mr. Ravindra Belur and Bhuvneshwari ma'am, one by one.
Mr. Ashish Makhija, I have again the basic question, is it legal? The reason I tell you, the possession can be of many kinds. Means it could be a forceful possession where the allotee would not have paid even 50% of the money. There could be a possession where 90% is paid. So, I mean, to me, this is too much stretch on part of IBBI regulator to do this, and I think it, in my respectful submission, this is absolutely illegal. I mean, there is no other word for me.
Okay, I think this is also related to one more thing. I think let's go back to CIRP. Let's not only concentrate on liquidation. Let's go back to CIRP. The people who are already in possession, if they submit a claim, do you admit their claim as an RP or not? That's the one question. Do you admit their claim? RPs are admitting their claims or not? If they are admitting the claim, naturally, then you see their claims are against the company, and they will have to be included. The plan will also include their portion also, because they can ask for refund of the money also. But in case they are in possession and they don't file a claim, then what happens? Does that property excluded? Here, if we go by the liquidation estate definition today, then everyone who is in the possession, they are not going to file a claim. I'm telling you. So they'll say, okay, we are in possession, nobody can touch our land. So therefore, we are in possession and this is to be done. I think this is going to create some sort of issues. Let's hear from Bhuvneshwari, ma'am.
First of all, as Ravi said, it's an illegal thing. If OC has not been attained and if it has been handed over, it is illegal, number one. Number two, this regulation is going to bring in lot of manipulations. He will go and keep on back there and say, I have been handed over. And there will be a bunch of lawyers who will be defending him, saying that he is living there for the past 10 years. Though there's no flat or it's only civil work is done, he will say, I'm living there for the past 10 years, I have been handed over. He may not give any document or anything. But this is going to create, and a lot of manipulations are going to happen in the real estate with this particular provision, I feel.
I think manipulations are already going on, ma'am. In fact, we have seen that, look, if you are appointed as an RP, naturally the builders, the promoters are not happy. And they have, under pressure, they have signed all backdated documents of giving possession and whatnot, isn't it? So therefore, it is going to create a lot of problems. I agree with that. I do not deny this. So do you suggest that this regulation should not be there at all?
No. See, unless the completion certificate is given by the government, and if the home buyer has paid the full money, then maybe the RP can give a registration, and once it is registered, naturally it cannot come into liquidation estate.
So
otherwise, it is part of the property.
For that, we don't require any regulation.
Exactly. That is legal. Yes. Okay. Otherwise, this is an illegal thing, sir.
Right. I think we agree to that. Yes, Mr. Pawan Kumar, any more comments?
See, there would be some peculiar situations where, you do not include them in the liquidation estate and company is liquidated. Okay. Then the person who is having possession will never have the title. And in future, he will not be able to sell that property because that property was never transferred to him. So this is opening up another Pandora box on title of properties, nothing else.
Therefore, that's a good point. I think what you are trying to say is that possession coupled with registration is more important. So even if somebody has a possession, I do not include in liquidation estate, but then it must become a responsibility that they should be registered tomorrow, because otherwise without registration, it is worthless, right?
Well, once the company is liquidated, then who is going to register? Who is going to sign the transfer deed? Then this cannot be registered. It will remain a titleless property and a person will not be able to sell anytime in future.
And maybe after 10 years, he can have adverse possession.
Yeah.
Okay. Anyhow, I think good point. I think this is also one of the points. So therefore, I think we can conclude by saying that regulation 46A is not necessary. It is violative of the law, the current laws which are there. Yes, Sharma ji, you have any comments to make?
We want you to enlighten us. I remember you having dealt with a position where the people who were in possession had filed claims. I remember long ago having heard one matter like this. Secondly, I think this may not be right to just say regulation 46A goes. If you put the word legitimate possession of a unit, will it be a better thing?
I think, see, when in law, Sharmaji, whenever the word possession is written, we don't have to write legitimate. In fact, see, that is what I said. Here, IBBI may also say, we are talking about possession means legal possession. So therefore, now RP will have to decide whether it is legal or it is not a legal possession. Or is it a possession only on as is, where is, because here then nothing is clarified out there. So I think you are right to that extent that, look, it should be clarified. But here we will presume if you, supposing this regulation comes and you come to me for a legal opinion, I will always say here the RP must examine that the possession is a legal possession. If it is an illegal possession, beyond the purview of the law, he's just sitting, then you have a right to evict him. So therefore, it will create more confusion. And in any case, if a legal possession has been given, then what is the need of regulation 46A? There is no need. Naturally, if you have given possession to somebody, say only registration is pending, then you may not cover that in the liquidation estate. If they are trying to cover only those cases, well, to that extent, 46A is fine. But because according to me, possession here would mean only legal possession. So it is going to.
Can you also enlighten us on people in possession to file claim or not?
Well, see, the point is there have been two sets of arguments on this. One set of argument is that if a person is already in possession, then naturally he has no claim because he has already got it. He has only a claim as far as the registration is concerned. That's all. He's entitled for registration. But if you go by RERA provision, if a legal possession has not been given, friends, may I request everyone to just mute themselves? Some background voices are coming. Okay. So therefore, the point what I'm trying to say is that in case you have filed a claim and you are already in possession, now should that claim be entertained or not? That's a big question. And most of the RPs are considering it. Because at the end of the day, project may not be completed, then obviously those people are entitled for refund because they may be evicted in liquidation. So here they are trying to protect, IBBI is now trying to protect such people. But the question which this will raise is, should these people be filing claims? Because tomorrow they will take a stand that, look, it is not a part of the liquidation estate, so therefore I need not file a claim. And my claim is still there. So now will the RP exclude them from the purview of the resolution plan? Or will it include them also? So there is going to be a lot of confusion. So according to us, 46A should be done away with. Okay.
Sir,
Yes.
also, the reverse also I want to highlight. If somebody has filed a claim and tomorrow he says, I am in possession, I have to be excluded, I think it should not be considered, isn't it? Because he has already filed the claim.
Filed a claim, yes. And claim means that you want a refund.
Yes.
You want your money back. And in fact, you see, this is another problem. Sometimes what people do is they go to the, say, RERA, they go to Consumer Forum and get a decree. And then they also file a claim. Then I always tell RPs that please treat them as other creditors. Because today, now they are not financial creditors. They have cancelled their flat. If they have obtained a decree in their favor, they should not be considered. But unfortunately, there is an NCLAT judgment now which says that decree holders should also be considered as financial creditors. So anyway, I don't know how that is going to play out. Okay, I think we can hear Mr. Gautam Bhattacharya. Sir, are you ready? You want to speak, say something? Because your video is frozen actually. Okay, maybe he's not available right now. So friends, any more comments on this? Because I think we have come to the end of this. And there are a lot of good aspects which have been discussed. Yes, Mr. Matthew, please go ahead.
Sir, just now you said
can you just a sir, Peer, can you unshare this document now? We don't require this. Maybe now we can see each other and have a discussion. Okay. Yes, sir. Yes, go ahead.
Just now you said that if a flat owner or a property owner holds a consumer court decree, okay, it's his right to get it, and he is not entitled to anything under IBC. That's what you are proposing.
No. My proposal is not that. Please understand, sir. If you are already in possession of something, why should there be a claim on the company then? What do you want from the company? You have already got the flat, whatever you wanted. This is the logic which is coming out to be. Now,
Okay.
supposing I have given you money for supply of machinery, you don't supply machinery to me, but I get possession of that machinery later on. Will there be my claim? The answer is no.
Okay.
So this is the logic. The point I'm trying to say is, but at the end of the day, there was confusion because this was not a legal possession. Because if the CCOC is not there, registration will not be done. So till the time registration is not done, it is not a legal possession. If it is not legal possession, it has to be a part of the company's assets. So therefore, RPs were considering their claims and also considering that property as part of the company's property. And the same logic was continuing in liquidation. But now, you see, in the liquidation, it is proposed that it should be outside the liquidation estate. So this is going to create confusion even in CIRP also. That's what my feeling.
Sir, a buyer, a flat buyer holds a consumer court decree that he don't want the flat, he want the money back. How will he will be treated? You said that it cannot be treated as a financial creditor, but some enclad.
Yes,
can you please clarify on that?
I'll tell you why. See, I gave a very strong, very long legal opinion on this. I examined the provisions of RERA. If I have got a decree, you have cancelled, supposing sometimes a request is also made, please cancel my flat and give my money. And money is not given and then the person files a claim. Claim is fine, I'm not denying. But the question is, what is the status of such a person? Now, my observation, my legal opinion on that is that he does not remain an allottee. Let's go to the definition of allottee. If you have cancelled your flat, you want your money back, then you are an ordinary creditor. According to me, he should be treated as other creditor. But there is an NCLAT judgment which says if you have a decree in your favor, you should be treated as a financial creditor.
I think because I hold a decree, sir. A decree is in the eyes of the law is a very valid thing.
No. Sir, that is all right. But will it change the status? Please tell me. Supposing you are an operational creditor, you get a decree. Will you become a financial creditor? Just because you've got a decree in your favor does not change your status. Does not change the category of the loan category of the dues which you have given. Category of the dues is as per the law. Either you are an operational creditor or this. Just because you hold a decree does not mean it changes the status. I do not agree with that judgment, with due respect, sir. Anyhow, that
also yesterday we had a discussion in ICSA forum only based on Vishal Chalani and others versus Debashish Supreme Court judgment, where the RP has brought in the home buyers who are having decrees as a separate creditor, and Supreme Court said what RP has done is not correct. They are all home allottees.
Yeah.
Maybe, I don't know, you are talking about the same NCLAT judgment.
Yeah, same judgment. But see, therefore, I beg to differ with that judgment because the proper, provisions have not been examined. Let it go to Supreme Court. We'll see that there are some different that is going to come.
I'm talking about Supreme Court judgment.
So you're talking about Supreme Court. Okay. I think that's maybe it applies only to the facts of the case. We'll have to see what were the facts of the case and then apply it. According to me, if you look at the person goes out of the definition of allottee. Please remember this. How is an allottee when he has cancelled a flat? He wants his money back. He does not it does not enjoy the status of an allottee. So
I think that clarity should come through a Supreme Court judgment, I feel. But it's the right thing. I also will say, if RERA has given an order or Consumer Court has given order for refund of the money, and the person is filing a claim, he should go out, he should become other creditors.
Other creditors. Yes. Only thing the IBBI can say is that there should not be any differentiation between such people, because in one of our cases, what has happened, the problem is with the resolution applicants. They say if the people who have decree in their favor, we are going to pay only 10%. And those people who don't have a decree in their favor, they are going to get flats. So those people are getting 100%, but these people are getting. So this discrimination is also not, a valid discrimination. People should actually think about it. Okay. I think Mr. Bhattacharya, do you want to say something, sir, on this?
Sir, another point is that whether home buyers should be treated as secured financial creditor or unsecured financial creditor.
There is no dispute on that. That please understand, as so far as the home buyers are concerned, they cannot be considered as secured creditor. They are unsecured financial creditors because they don't hold any security, sir. The flat is only allotted to them. It is there's nothing. You see, because as Bhuvaneshwari ma'am said, allotment is only that you are entitled. But supposing it is not built, how can it be a security? So it can't be treated as a secured creditor, right? Unless and until the law says otherwise. But law is actually silent on that. Okay, so friends, I think we have had a very good debate today, with good discussion, good interactive this thing, and I must thank all the participants from my bottom of my heart to join here and give their valuable suggestions. I think I am always enriched by these kind of suggestions, and definitely we are going to make a better world for IPs after all these discussions. So thank you so much, and over to Peer on ICSI for your closing comments.
Thank you, sir.
Peer, are you there?
Yes, sir. Sir, on behalf of ICSI IIP, I would like to extend our sincere thanks to you for sharing your thoughts and experiences on the subject with all of us and making this discussion very interactive and informative. Thank you so much, sir.
Thank you. Thank you. It has been a pleasure.
Sir.
Thank you, sir.
Before ending the discussion,
Thank you, sir.
I would like to mention
Thank
that
you very much, sir. Thank you.
apart from suggestions received today, participant may send suggestions to us on email also, so that ICSI IP can consolidate the same and submit the same before IBBI for daily consideration.
Okay, yeah, that's a good point. If anyone of comes, you see, another thought comes, or maybe those who have not contributed, they want to contribute, you can still send an email to ICSI, and ICSI IPA will consolidate them and then send it to IBBI. I think that's a good thing. So thank you so much, friends, for joining today and being a part of it. Thank you.
Thank you,
a
sir,
lot.
for
Thanks a
sharing
lot.
knowledge and time. Thank you very much.
Thank you, sir.
Thank
Thank you. Thank you. It's always a pleasure. Thank you.